cessation in the hostilities that caused detention in the first place. I think it's a very difficult question, and what makes it difficult is just the fact that we are dealing with a quote-unquote war, and there are many who question that paradigm in the first place, but we're dealing with a war that potentially has no end, and certainly has no clear-cut end. But it does seem to me that that in and of itself is an area where the courts, I believe, will be open to future cases that say, okay, enough is enough, whatever that war was back in 2009 or 2010, it's now 2015, and there's no longer a justification under the AUMF or the laws of war for this continued detention. Now, I do know that this administration, the Obama administration, at least as I read the final task force report that was actually issued back in January but came out just a couple weeks ago publicly, that report indicates that there will be an ongoing review of cases for those individuals who are detained in the category of being detained without trials or military commission proceedings and that sort of thing. So I think there you could fashion something similar to what we're familiar with, which was the administrative review board process that the Department of Defense applied on an annual basis to the detainees that were held prior to the time that Boumediene was decided, and we got back on track with real habeas proceedings. So you think a review like that would be better addressed either by the courts or by the executive branch and not by Congress at all? I don't know. I haven't given enough thought to really weigh in on that.
I'll jump in with another question. Now the report is ready and you have presented it, and you are addressing the Congress, that Congress should not overstep its authority. But Congress is not only one body, it's made of many individuals. How are you approaching them? What kind of feedback have you got, if you have already made any particular congressmen or women who are positive towards this, or what is the next step you are looking for?
I don't know that they have the report. Do they? I don't. No.
It's just released now, so that comes next.
You're the first to know. Take it to your congressman. I have no idea what their response will be, but nobody is here to denigrate the responsibility of any branch of government and what it perceives to be its responsibility. And the issues then are joined or not joined.
Hi, my name is Deb Meissner from Shootout. This is really true.
He can hear you, but I can't hear you.
Sorry. I have a really super basic question. The ideas of control and competency come up throughout this report and in this morning's discussions. Can you highlight what those questions are that these arguments are addressing? Because I'm just not clear on what the competency and control issues are.
Competency of counsel, competency to be tried, competency to bring forth the application. To define a little better what you're talking about, if you can.
Unfortunately, I can't, because it's just hearing when you give the issue of the competency of the courts to take on these. I guess, where does the question in the court's ability come up? If this is what judges do and what the court system does, what is so unique about this issue with respect to the detainees that would require this conversation?
Right. Well, I think it's a good question. It's a basic question, and I think in some respects what's being challenged and what's being addressed by this report is the question of whether or not courts are competent to fashion the kinds of procedures that were applied in our habeas case, whether they are competent to take a law like the authorization for the use of military force and apply that law in individual concrete situations that each one of the Guantanamo detainees represents, or whether they're not competent to do that, and instead what needs to happen is that Congress, the legislative branch, should come in and say, these are the procedures that you should follow, courts, and these are the standards that you should apply in implementing our legal mandates in the authorization for the use of military force. And what I would say is that courts are certainly competent to develop procedures. It's the courts that normally are the bodies that develop their own procedures. It is unusual for courts to be sort of dictated as to how it is that they will develop procedures for particular cases that come before them. And I would also say that in this case, contrary to what some might suggest, that is that the courts are actually legislating and not doing what they do, which is to be judges, I don't think that's the case at all. I think the courts are taking legislation that is already there and fleshing that legislation out in its context in individual cases and applying that law that has been adopted by Congress to the individual fact situations that come before them. And so I believe that the idea that this is something that the courts either shouldn't have control over because it belongs to Congress, or that they're not competent to do because they're just courts, by the way, and they're not Congress, in both respects, I think misses the point. And I think that that's why it's so important that this report goes through and catalogs how the courts have done this, and that it is exactly consistent with the kinds of things that judges do all the time.
Well, and you might gain some additional insights, if you don't already have them, by picking up the Federal Rules of Civil Procedure, and all the things that are known to man in a courtroom, they've been dealt with in one fashion or another, or usually have. And it might be helpful to you to look at it and see about those procedures that they perceive now that they routinely use before Guantanamo ever came along.
There is one more question, yeah.
Now, she's an authority. She's an expert.
I'm just a proud sister of Guantanamo Habeas Council here. But, you know, one of the other arguments that you hear, of course, is that because, you know, it appears as though different judges could apply the same facts to the same law and come out with a different result at the end of that, different conclusion, that somehow that's an indication that there's a problem and that Congress needs to provide legislative authority that restricts the judge's abilities to do that. And as a litigator and a judge, I'd be interested in your response to that. And then the second thing, and
That's very dangerous territory because you always have disagreement. You always have shades and permutations of all of these things, where one sees it one way and one sees it another. One hears evidence and it is not the way the other hearer has gotten it. And so examination is, generally speaking, the best place to start. Look at it and see what there is that is different and see whether it was properly handled as a judge.
I would say, in addition to that, and I agree with that, I think different judges are going to see things differently. But equally important is the fact that each of these cases is unique. The facts that are presented to Judge Kennedy in Case A are different than the facts that are presented to Judge Kennedy in Case B or to Judge Leon in Case C. And so I would be a little skeptical of those who say, well, different